afternoon, everybody. Welcome to CUHK Law. Welcome to this CCTL Corporate Law and Governance Cluster Seminar. My name is Lutz Christian Wolf. I'm the Dean of the CUHK Law, and it's my great pleasure to introduce today's speaker to you, Professor Chao Xi. Professor Chao Xi is a professor at CUHK Law and an outstanding fellow of the faculty. He also serves as Associate Dean Research, and he's also the head of the Granting Division of Law. And in addition to that, another hat he's wearing, he is the director of the Chinese Law Program of the Hong Kong Institute of Asia Pacific Studies at CUHK. Professor Xi specializes in comparative corporate law, securities regulation, and financial regulation, of course, with a particular focus on China. And he has published extensively in leading peer-reviewed international journals. His research is substantively funded by the Hong Kong SAR Government Research Grants Council, the PRC Ministry of Education, the Government of India, and there's also support from the Sumitomo Foundation. Professor Xi also holds various positions in leading overseas institutions. He is an editorial board member of a number of international peer-reviewed journals. And he is, last but not least, a member of the Chartered Institute of Arbitrators. And he's on the panels of arbitrators of several arbitration institutions. And not surprisingly, on a regular basis, he is invited by law firms, business organizations, and government bodies to give expert opinions or to work with them on a consultancy basis. Having talked too much already, please let's welcome Professor Chao Xi, who is today talking about the question, are U.S. listed Chinese firms a minefield? A board perspective. Over to you, Chao.
Thank you, Dean Wolf, for a very generous introduction. I was pleasantly surprised to see a good number of turnout despite today's adverse weather condition. So if any of you is actually on your way back to the office, I hope you have a smooth and a safe journey that way. Now, this talk is pretty much based upon a paper which was recently published in the International Lawyer, which is really the official publication of American Bar Association's International Law section. So for those of you who are interested, it is freely downloadable from SSRN, which is probably the go-to place for research in social sciences subjects, including law. Now, this research is a collaborative work of myself and a doctoral researcher that I'm supervising at CUHK Law, Ms. Yurong Huang. I believe Ms. Huang is with us today. I hope, Ms. Huang, you are there. Now, so this is a research which we started off back in April, May 2020, and we think this is our engagement of an ongoing debate on one of, if you like, a flashpoint issue in ongoing China-US geopolitical tension. Now, the focus is on a cohort of Chinese companies, those companies which are listed in the US stock exchanges. Now, so for those of you who are following the news coverage on the China-US tension, you would come to realize that just recently there were a number of Chinese firms which found themselves at the crossfires of that tension. A few firms have been delisted by way of a presidential executive order issued by the Trump administration towards the very end of its 4 years tenure. Now, so this is if you like, this is an ongoing issue. I think perhaps as pretty much as a result of that, this paper, which was put up on SSI and this if you like, the hub of social sciences and legal research, has got quite a bit of attention, I think. And recently, we have been invited by Oxford University's business law blog to make a contribution based upon this publication. So I hope this is a topic which interests this audience that we're having today. Now, before I move into the substance, allow me to give you a broader roadmap of today's talk. Now, I will start off by giving a broad introduction of the research questions that we set out to address. Then we will give you a brief overview of some of the key attributes and the features of the cohort of the so-called Chinese listed Chinese firms, based upon a data set which we have collected, we have constructed specifically for this research. I will then proceed to say a few words on the attention which has been given to the board and the board committees in the corporate governance movements in the past 2 decades also. Now, then to set really the stage, the legal stage, if you like, of our empirical survey of board and the board committees of U.S. listed Chinese firms, I will say a few words on the legal and the regulatory rules on board and the board committees on U.S. law, as these firms are all listed in the U.S. exchanges, and also on the BVI Cayman law, as will demonstrate a large, an overwhelming majority of these firms, these sample firms, are actually BVI or Cayman Island incorporated. Now, with that in mind, I will proceed to really take an empirical look into the board and the board committees of all these 249 U.S. listed Chinese firms. Now, this was done by we manually collecting all these data from public accessible company disclosures. Now, on that basis, I will take you through the main findings and the conclusions, if you like, some of the initial conclusions that we have had as a result of this research. So this is the roadmap. And let me just give you a brief introduction to really set the question out just in front of you. Now, some of you, perhaps many of you would recall, back in April last year, there was really well, some would even call it another corporate scandal relating to U.S. listed Chinese company. At the center of this corporate fiasco, it is Luckin Coffee, Luckin Coffee. Now, this is a operator of a coffee shop chain, if you like. It is Cayman Islands incorporated. At the time of this scandal, it was NASDAQ listed, but its operation was pretty much based almost entirely in the mainland China. Now, if measured by the number of coffee stores, it claimed to be the largest coffee chain in China back then. Now, I think outnumbering Starbucks back then by a big margin. So it was really touted as a firm which is likely to up and Starbucks dominance in the coffee drinks market in the PRC back then. Now, Luckin Coffee was founded back in 2017, and it went public in NASDAQ in May 2019. Now, that actually made Luckin Coffee one of the fastest company to have gone through the journey from its founding to a public, to a listing, to IPO, if you like. But the rise of Luckin Coffee was as short-lived, well, brief, if you like, as the demise of Luckin Coffee. Now, into the 11 months of its IPO at NASDAQ, it's the day after April Fool's Day. Luckin Coffee made a disclosure, if you like, an announcement, which really sent a shockwave across the market. Now, basically, there was, if you like, blatant fabrication of sales, of Luckin's reported sales. So pretty much of its reported sales were essentially, well, basically existed only on the paper. Now, there was a lot of follow-up investigation into the scandal, but which we won't be able to go into every details here today. But it was noting that Luckin was, well, regulatory actions were really taken against Luckin Coffee, both in the United States and in mainland China, and Luckin was really delisted from the NASDAQ in July 2020. Now, this was probably for some observers, this was probably just another, individual scandals, corporate scandals, which investors ran into from time to time. But clearly, that was not really just another scandal, corporate scandal in the U.S. market. The timing, if you like, if you were to be cynical, then the timing of this corporate scandal was most unfortunate. It was right at the time when the U.S.-China tension, trade and geopolitical tension was at its heyday. For example, SEC immediately after this scandal was brought to light, SEC made the U.S. Securities and Exchange Commission made a public remark with really unambiguous reference to China, which quote, "There's a substantially greater risk that disclosures will be incomplete or misleading, and in the event of investor harm, substantially less access to records in comparison to U.S. Domestic companies." So the reference of this remark was really made to China. So it was, if you like, a warning, a caution, if you like, drawn by SEC to investors in the U.S. market. Now, another development, a bit more recent development of the Luckin scandal was clearly the passing of the unusually, if you like, a unanimous passing by the U.S. Senate and House of this Holding Foreign Companies Accountable Act. Now, this was unusual because this is perhaps one of the very few, if not the only piece of U.S. legislation which really won unanimous and bipartisan support from the Democrat and the Republican, which otherwise always found itself in gridlock, to unanimously to join force and support a piece of legislation. It was signed into law by Trump in the final weeks, I think, of his presidency. Now, I think there's been a lot of media coverage of this law, and I don't need to go into the details, but essentially the thrust of this legislation, that it's multifaceted, but the thrust of this legislation is really to require U.S. listed Chinese companies to comply with U.S. audit requirement within 3 years. Otherwise, the securities will be prohibited, but basically they will be delisted from the U.S. capital markets. So this is really the introduction, the broader, if you like, the broader background of our research. Now, the research question that we were trying to engage were pretty much driven by, well, part of it by this event, which obviously, which was really under the limelight, and partly by some of our academic intellectual curiosity. Now, there are two questions interrelated. Now, the first question we set out to address empirically is that whether the U.S. listed Chinese firms as a group, now we're not looking at individual firms, but we are trying to find out whether the cohort of U.S. listed Chinese companies, whether they're just truly corporate governance minefield to be avoided at all cost by investors, international investors, including U.S. perhaps and perhaps Hong Kong based investors. Now, this was probably really pretty much the essence of the outcry that we see in the popular media in the aftermath of Luckin. Now, so this is a question that we sought to look into, the first one. Now, a related question is whether the Luckin scandal reviewed the commonly shared deep-rooted governance deficiencies in this cohort of U.S. listed Chinese companies, or whether Luckin was just a outlier. All right. So these are the two empirical questions that I would think which together will engage some of the debate, which was quite popular back then, and I think in a way is still ongoing nowadays. Now, our apologies. Our perspective is slightly different from this decade-old now debate on the question of access, especially U.S. regulatory access to the audit paper of Chinese, U.S. listed Chinese firms. Now, that is a very important debate, and deservedly, it has pretty much taken up much of the attention, academic attention, and perhaps policy attention in the past decade. But that issue, which is access to the audit paper located in China, is proved to be complex and intricate in a lot of senses. So it is very unlikely that issue will get resolved in the immediate future. So we think to approach these questions from a broad perspective might shed some new insights into the current debate, because the board and corporate governance reforms pertaining to boards, corporate boards, has pretty much been the focus of those reforms in the last 2 decades. And so for that reason, we are looking at these two research questions from a board perspective, which we'll demonstrate in a few seconds. Now, as we have I've explained, we have created 2 unique and comprehensive datasets specifically for the purpose of this research, which we'll explain well, in our presentation and talk today. Now, the first question, which is a question which we found it to be puzzlingly empirically difficult, which is what are U.S. listed Chinese firms, or 中概股? Now, this is a term which has been widely used in policy discourse, in the popular media, and in the academic discussions. But apparently, there has been no commonly accepted definition of this U.S. listed Chinese firms. Now, so for example, in U.S. Congress, there's a committee on U.S.-Chinese economic relationships. They have kept and they have updated from time to time a list of U.S. listed Chinese firms, but there was no definition. There was no, if you like, official definition coming from U.S. Congress as to exactly what this term, which is at the center of the debate, actually refers to. Now that really puzzled us as we started the research. So we looked into different databases, commercial databases, and we found the definition, the way of categorizing this cohort of U.S. listed Chinese firms by one of the leading data provider on Chinese listed companies, Chinese corporate governance, WIND, to be particularly, well, to be more sophisticated and better suited for our research. So according to WIND, which is one of the leading data providers, as I've mentioned, on Chinese firms. Now, it is based upon the following criteria that in their data set, they would categorize a U.S. listed company as a so-called 中概股 or U.S. listed Chinese firms. So this is what they looked at. Now, first of all, they asked whether a company, whether it's disclosed the main business operation is domiciled in mainland China, so it's basically a domicile principle, or is whether its revenue derives predominantly from mainland China. So this is about a revenue, perhaps not a surprise. But in addition to it, they also look at the identity of a firm's majority or controlling shareholder. Now, based upon presumably publicly available information. Now, they would ask whether that shareholder is Chinese, mainland Chinese, I suppose. They also asked, WIND also asked whether it has got a Chinese name. They also look at the official website of the company in question and try to determine whether the default language of the official website is set to be simplified Chinese. Now, and finally, they also look at the headquarters of the companies in question, whether it is geographically located, physically located in mainland China. So this is a list of criteria that the WIND has used to determine the cohort of U.S. listed Chinese firms. And this is what, in our view, the list of criteria help to serve the purpose of our research, and therefore we have pretty much adopted the same criteria. Now, with this criteria in mind, we have then collected the information about these 249 firms listed in NASDAQ and NYSE, the New York Stock Exchange, at the end of 2019. Now, as I have indicated, the research, the data collection was pretty much conducted in the first half of 2020. Now, there are a small number of Chinese listed, U.S. listed Chinese firms, which are listed in other stock market in the States. But for the purpose of this research, we have excluded them. But the number of those firms is small, I think smaller than 10. So we believe any conclusions drawn upon our NASDAQ plus NYSE datasets would stand the ground, if you like. Now, altogether, we have 224 firms. I do apologize if I gave you a misleading number. I think I just now I said 249. It should be 224 firms, out of which 149 are NASDAQ listed at the time of data collection, and 75 were NYSE listed. Now, this figure shows the distribution in terms of the listing years. So, as you could tell, back in the 1990s, there were a relatively reasonable number of Chinese firms which went public in the U.S. Those two, NYSE and NASDAQ. But really, over 70% of the firms went public in those two markets in the past decade, between 2010 and 2019. Perhaps not really a surprise. That's perhaps mirroring the rise of the Chinese economy and the rise of the Chinese private sector in the past decade. Now, there's also a concentration of industry distribution. Now, close to 30% of the firms are high-tech firms specialized in the IT sector, which this figure helps to demonstrate. Now, we also look into a number of other attributes of our sample firms. Now, you have the capitalization, the size. The total market capitalization of sample firms were close to 2 trillion by the end of 2019, with an average market capitalization of over 8 million US dollars. Now, that may give one the impression that these Chinese U.S. listed Chinese firms tend to be large, but actually, if you look at the median value, it was only just over 300 million US dollar. Now, which is an indication that when it comes to size, there's a great variation among this cohort of sample firms. Now, as you would imagine, Alibaba, which is one of, if you like, a star U.S. listed Chinese firms, pretty contributed a lion's share to the total market capitalization of our sample firms. Now, many, if not a majority, of U.S. listed Chinese firms were actually small, if not micro, in size. Now, contrary to the common belief that U.S. listed Chinese firms tend to be state-owned, now our data doesn't really support that common belief. Now, state ownership is not actually common among the cohort of our sample firms. Less than 6% are state-owned firms. Now, we look into the ultimate controller of all these listed firms, and we manually check their identities. They're not as many state-owned firms as it was generally believed. Now, the place of incorporation. Now, we have looked into their place of incorporation, and close to 90%, 85% of non-SOEs, they were incorporated in BVI or Cayman. Now, that's which appears to be these two jurisdictions appear to be quite popular with non-SOE, non-state-owned Chinese listed Chinese firms. Now, I hope that sets the empirical stage of our research. Now, but before we look into the board and the board committees of this cohort of U.S. listed Chinese firms, let me just say a few words about our perspective, which is board and the board committees. Now, the board, the role of the board has been one of the central issues of academic and policy debates around the world. Now, empirical research has indicated that the board may serve different roles, and it could be individual company, individual firm specific. Now, broadly speaking, and this is a really broad-brushed observation. Now, a board in a unitary structure, now especially in a common, but pretty much in a common law context, serves a number of roles. Some would say the board plays the role of an advisor. Others may argue the board plays the role of steering the company, especially in its strategic directions. Others will say, the board plays in a common law jurisdiction, plays a very important oversight role. And that is the role that is the focus of our perspective. And it has a lot to do when it comes to the oversight role, which is the monitoring role of the senior management, of CEO, if you like, and other C-suites officers, while in some cases they would say, well, even the controlling shareholder, research indicates it hinges the ability of the board to play that monitoring, that oversight role, hinges pretty much on the independence of the board from the management and from the controlling shareholders, which perhaps in reality, in practice, actually play a very important part in the appointment of board members, especially, including the independent board members. Now, so in board independence has been a central corporate governance reform issue since the turn of the century. Now, some of you probably would recall this Enron scandal back then, which obviously sent a shock wave in the U.S. stock market. So the Enron scandal back then gave rise to the Sarbanes-Oxley Act in 2002, for example, which required a majority independent board. Now that was back in 2002. But since then, this, if you like, this Enron scandal, corporate scandal-driven corporate governance reform has really rolled out around the world. So, for example, the OECD back in 2019 published a corporate governance fact book. Now, in this fact book, it made a very interesting factual observation, which I quote here. Almost all jurisdictions surveyed, basically, have introduced a requirement or recommendation with regard to a minimum number or a ratio of independent directors, and the recommendation in different jurisdictions for boards for boards to be composed of at least 50% independent directors, and that appears to be the most prevalent voluntary standards in all these dozens of jurisdictions surveyed by this OECD report. Now, so really, the independence is a central issue when it comes to the role of the board in corporate governance. Now, generally, the board in many jurisdictions, especially in common law jurisdictions, sets up a number of subcommittees or board committees. Now, these include the three most important board committees include the audit committee, the compensation committee, the nominating and the corporate governance committee, Now, these are all the committees which are very popular, which are commonly seen in the jurisdictions, for example, including the United States. Now, the reason we are also focusing on the board committees is that a large body of recent research has shown that really much of the businesses, the work, if you like, of the board has really been done not at the board level, well, in its, if you like, in assembly, but much of the decisions has really been taken at the committee level. So it is committee. The argument has been that has really done the job, rather than the board perhaps meets 3 or 5 for many companies, if not for most companies, a year, which wouldn't really be able to direct its attention to all the details of how the company is actually run by its management. Now, the independence, as we have said, the independence of the board and its committees, according to research, some of the leading research, helps to ensure the integrity of financial reporting and more generally to enhance firm value. Now, what I have here is just 4 pieces of empirical research that these are leading research studies, primary studies, which really demonstrate that independence matters. Independent directors matters not only for the board, but also for the board committees, in particular for the audit committee, which I wouldn't be able to go into details just today. Now, having addressed the general perspective, now having explained why we're taking the board and the board committee perspective, and why independence looms very large in our research, let me just go into some details, but not all the details of U.S. law in the first instance, and then I will say a few words about the BVI and the Cayman Island law on board and the board committees. Now, we should, for the U.S. law, we should perhaps start with the U.S. federal law. Now, to be specific, in the Sarbanes-Oxley Act of 2002, there's a section, especially there's a section 10A3, and also under this old, almost 1 century old, well, 80 years old Exchange Act, there's a provision on the board independence issue. Now, which pretty much delegates the authority to the SEC's departmental, if you like, agency or lawmaking. Now, what is interesting is the SEC, which has been delegated authority to make rules on board and board committee independence, it doesn't really impose any requirements of independence on directors generally, and it doesn't really even require any companies to set up an audit committee. But the big but here, but for companies which has already set up an audit committee, then the Exchange Act and the SOX, which stands for Sarbanes-Oxley Act in 2002, they both require that each member of the audit committee to be a member of the board of directors, and clearly, even more importantly, to be independent. Now, for this audience, a natural question would perhaps be how is independence defined? Now, that is really the holy grail of the discourse. Now, we may be able to discuss this in the Q&A, but here let me just skip this. But just to say, well, the notion of independence, the concept of independence, is a rather nuanced one, and there appears to be quite a bit of a disagreement, even among the most learned scholars and policymakers, as to what independence in the context of board and board committee should actually entail. Or so there's no consensus in a way. Now, there's some agreement, but clearly there's more disagreement than what has been agreed. Now, including, for example, whether a social relationship should be a component of independence. Now, we won't be able to go into detail just today, not in the talk itself. Now, having said this, there's a very important exception in the law, in the U.S. federal legislation. And this appears to be exception which a large, if not an overwhelming majority of our sample firms, there's 224 firms, had relied on. And this is the so-called FPI exceptions, which is the foreign private issuer exemption. Now, so essentially, the thrust of exemption is really to exempt those issuers, those listed companies, which are incorporated outside of the United States, including BVI, Cayman Islands, including perhaps China, perhaps Hong Kong, and other jurisdictions, as long as it's not at the United States, from the SEC, from U.S. federal legislation and SEC's requirements. Now, if there's a conflict between the SEC requirements and the U.S. Federal legislation on the one hand, and the regulation standards, corporate governance regulation and standards, included of these companies' home jurisdiction. All right, so that's something which we'll probably need to bear in mind. Now, having dealt with that, we should also add well, much of the independence requirement in relation to board and the board committees are more really based upon well, NASDAQ and NYSE rules. Now, we have prepared a table to really summarize the key features of the listing rules requirements, if you like, for board composition and the committee composition under NYSE and NASDAQ listing rules. Now, if you compare the two, as you can probably see from the table here on the screen, you will say, well, these requirements, these standards, listing rules appear to be quite similar. Now, if anything, the NYSE board and board committee rules appear to be slightly more stringent than the NASDAQ rules. Now, so for example, when it comes to nominating committee, the NYSE rules generally require that a nominating committee to be set up. Whereas this is not a requirement for NASDAQ, right? But the differences are relatively minor. Now, you have all these nuances, all these differences between NASDAQ and the NYSE rules. And if you're interested, you can take a look at those comparisons that we have done in our paper. We won't be able to go into the details in our talk. Now, having addressed this U.S. law perspective, let me just say a few words about the BVI and Cayman Islands law. Because as we have indicated just now, there's a very important statutory exception, which is the FPI exception. There's a foreign issuer exception on the U.S. law, which really enables, if you like, or provide a leeway for those U.S. listed companies which are incorporated outside of the United States to actually seek exemptions, to seek a waiver from all these requirements under U.S. law, and including the listing requirements. And so, as we have indicated, more than 80%, now close to 85% of non-state-owned U.S. listed Chinese companies are incorporated in BVI and Cayman Islands. So it's perhaps worth saying a few words about the BVI and Cayman Island laws here. Now, the thrust of our analysis is basically that, well, the BVI and Cayman Islands law take pretty much a laissez-faire, if you like, stance on corporate governance arrangements. Now, put it in a more positive terms, now essentially the BVI and Cayman Islands legislation and legal regimes, they really give companies an extraordinary degree of broad degree of contractual freedom. So BVI and Cayman Islands incorporated firms generally enjoy considerable flexibilities, if you like, regarding the composition and independence of board and the board committees. Now, in other words, in very practical terms, if a U.S. listed but BVI and Cayman Island incorporated Chinese company, company with substantive operation with in mainland China, seeks to invoke this FPI exemption, it can. Essentially, then there's not really a legal obligation for those U.S. listed Chinese companies which are incorporated in BVI and Cayman Island to really comply with all the U.S. federal legislation and the listing rules that we have presented just now. Now, so they have a free hand, put it the other way. Now, but remember, that is from a legal perspective, which means they are not legally obliged to comply with the rules, but that doesn't mean that, they will necessarily invoke the FPI exemption, because in practice, companies, most companies at least, which have a subpar corporate governance standards or practice, would be typically be liable for corporate governance discount, the so-called corporate governance discount, when it comes to their share pricing, the PE ratio, put it in more technical terms. All right, so in other words, it is the market, the argument might be, not really the legal requirement that has really moved all these non-US incorporated companies, including Chinese companies, to voluntarily, if you like, or to surrender themselves to the US corporate governance regime. Now, if you're coming from an academic perspective, this is really the essence of the so-called bonding effect, which is, you have these companies coming from a jurisdiction with a lesser degree of corporate governance standards, voluntarily bind themselves by the U.S. corporate governance standards. So sending a strong signals to investors, they're good citizens. So this is, if you like, a messaging, a signaling effect. Now, with all this background, let me just say a few words about our empirical findings. The data set first. Now, what we did was to hand collect firm level data. This was entirely original. To the best of our knowledge, no one seems to have done it before. Now, so we have 211 sample firms. So these are all privately owned firms. We have excluded the state-owned firms from the empirical survey. Because clearly these firms are subject to generally to a separate regulatory regime, and most of them are not incorporated in Cayman Island or other, if you like, tax haven jurisdictions. Now, we hand collected firm level data in relation to board and board committees. We collect information on the number of directors, the number of independent directors, the number of board committees, and their names. If the information is available, we also collect data on the number of committee members, the number of independent committee members, and independence, and whether the committee chairperson of each of the board committees is declared to be independent. Now, that's a data set, and this is a unique data set. Now, our finding we have all the details in our paper. So if you're interested, please do take a look at our paper. But let me just give you a quick summary of what we have found empirically. Now, first of all, board size. Now, the board size of this cohort of non-state-owned U.S. listed Chinese firms ranged from 4 to 11. Now, the average board size of NASDAQ listed firms, which is the sub-sample, is 6.42 with a median value of 6. Now, the average board size of NYSE listed Chinese companies, Chinese firms, or sample firms, was 7.21 with a median size of 7. So, well, at least on the face of it, NYSE Chinese listed Chinese firms tend to have a larger board than NASDAQ listed Chinese firms. Now, this doesn't really mean much in a way, because empirical research, comparative research has shown early that the size of the board and the sophistication of the board structure tend to correlate to, if you like, the majority of a company, and also to the size of a company. So in other words, well, smaller companies and the newer companies tend to have a smaller board and less sophisticated structure-wise board committees. And the larger board and the more established companies tend to have a larger board and structure-wise more sophisticated board committee structure. So this is probably, in a way, our data perhaps is pretty much in agreement with prior research, as generally NASDAQ-listed Chinese firms are smaller, and they tend to be, high-tech companies tend to be newer and less mature in that sense. Now, but what was counterintuitive in a way was that while our NASDAQ sample firms, Chinese listed firms, recorded a higher level of independence than NYSE listed Chinese firms. Now, so we recorded an average board independence of 55% for NASDAQ sample firms, compared to the 47% for NYSE sample firms. And the median value was also, well, there's a 10% difference between the two. Now, this was really counterintuitive. Now, as I have indicated earlier, empirical research generally indicated that larger firms and more mature firms, they typically enjoy a more independent board. And that is not the case for our research. This is something which we haven't been able to offer an answer, a ready answer yet. Now, then we look at take a look at our board committee. Also, we have reported all the details in our paper, but let me just try to very quickly summarize our findings here, which is all sample firms have got an audit committee. The establishment of the 3 required committee, which is audit committee, compensation committee, and nominating committee, sometimes called a nominating and a corporate governance committee, is prevalent now in the vast majority of our sample firms. Now, all these 3 board committees have been set up, have been established. Now, remember, these Chinese firms can really, from a legalistic point of view or formalistic point of view, they can really, not to have these committees, but usually they do. Now, the number of committee members ranged from 2 to 5. Now, typically, 3 is a good number, is a common number. This is another finding. And the board committee independence, this is, again, slightly counterintuitive, which is when it comes to audit committee, the range for NASDAQ appeared to be narrower, if you like, well, more independent, meaning than the NYSE board committees, which again is a bit of well, counterintuitive. And this stays pretty much the same in relation to compensation committee. Now, so NASDAQ board committee, well, sample firms board committees tend to be more independent, and the same holds also for the nominating committee for NASDAQ sample firms. As again, we are still not entirely sure as to exactly why and how, but this is our empirical finding. Now, let me just then turn to our second research question. Now, our first research question was whether, while the Chinese firms, U.S. listed Chinese firms as a group, as a whole, are really corporate governance minefield. So I hope those empirical data has shown something, which we'll do the comparison in a conclusion. But let me just turn now to our second research question, which is whether the Luckin Coffee, whether it is just representative of the deep-rooted, the commonly seen corporate governance problems that have plagued the whole cohort of Chinese U.S. listed Chinese firms as a whole, or whether Luckin Coffee is just an outlier. All right, so this is a figure which shows well, where Luckin Coffee situated back at the time of our data collection. Now, so we have done use these four figures to visualize where Luckin stood. All right. Now, this figure shows the board independence of NASDAQ listed Chinese firms. And the red dot, so each of the dot stands for one NASDAQ listed Chinese firms. So you have 149 dots. Now, LK stands for Luckin Coffee, and this is the red dot. So clearly, LK is really, Luckin Coffee was really to the bottom. It was much closer to the bottom of this range than to the center of gravity, and clearly than to the more independent NASDAQ listed companies. So it's one of the least independent. Its board was one of the least independent among the 149 NASDAQ listed Chinese companies. Now, when it comes to audit committee, so you see this well, the vast majority of 149 NASDAQ listed Chinese firms, they had a 100% independence, which is what essentially what the audit committee is supposed to be 100% independent. And Luckin Coffee again is one of the very few, which is the audit, where the audit committee was not entirely 100% independent. Now we then had this comparison of we placed Luckin against the other Chinese NASDAQ listed Chinese firms. Again, I think the message, the visual message, is very clear, which is it is not well part of the mainstream, if you like. It's always one of the outliers. It's one of the least independent firms in the market, in the cohort, if you like, NASDAQ listed Chinese firms. Now, what is our overall conclusions, our overall findings? Now, let me just strike out a few. Now, first of all, and this is somewhat counterintuitive, which is NYSE listed Chinese companies, which are generally large in size as measured by market capitalization, and more mature as measured by the year of listing, and perhaps, well, in a way, the year of founding. Counterintuitively, they have less independent boards and less independent board committees than the NASDAQ listed or counterparts, NASDAQ listed Chinese companies. As we have indicated, it's really a question for our future research to find out exactly as to why they are listed. They're less independent, while the existing theories suggest they should be more independent. Now, the second line of conclusion is that the board and the board committees of Luckin Coffee, which is clearly at the center of this corporate scandal, well, very illy timed in a way. It could be just a coincidence, but clearly that was just another flashpoint in the U.S. Sino-U.S. tension, geopolitical tension, trade tension, economic tension, technology tension. It was really among the least independent in its own terms. Well, in that sense, meaning in the cohort of 149 NASDAQ-listed Chinese firms. So it's just measured at not just against the whole cohort of thousands of NASDAQ-listed firms, but even just against its own group, its own peers of NASDAQ-listed Chinese firms, 149 of them. It is really among the least independent. All right, so it's in that sense, it's perhaps it's really outlier. It's not standard. Yeah. Now, the third observation that we have is that our Chinese firms listed on the NYSE and the NASDAQ on average have slightly less independent boards and board committees than S&P 500 firms do. Now, this perhaps lends, some might argue, some support to, for example, the SEC remark that the whole group of Chinese, well, U.S. listed Chinese companies are simply more risky. But if you go into the literature, the academic literature, you would realize independence in general, as we have indicated before, increases with the size of a company, with the maturity of the company. So our argument is that the S&P 500, which essentially this is a index of some of the largest, at least medium-sized cap U.S. listed companies, is perhaps not a nice, useful benchmark. Even the Russell 3000 firms, which is perhaps a good representation of the universe, well, in terms of value, they contributed to about a 98% of the market value. But even that is not really a good benchmark to use against, to be used against Chinese listed companies, because as our research has indicated, a large percentage of Chinese, well, U.S. listed Chinese companies, they belong to so-called well, micro companies, micro cap companies. All right. So therefore, our argument is that is the early empirical research shows that group of company is known for its corporate governance, if you like, practice, which is supposed to be just a bit less independent than their more independent, they're more mature and the larger peers. So our suggestion, our initial conclusion, is that care must be taken in interpreting this finding. Now, we just can't compare just the numbers. Now, the numbers, the percentage should be understood in context of early research. Now, so what is our overall message? I think our overall message is that, well, our research, which represents, I think, we believe, one of the first empirical research in the board and the board committees of Chinese, U.S. listed Chinese firms, doesn't really offer much support to the views which categorically labored the whole cohort of U.S. listed Chinese firms as a minefield. Well, obviously, a caveat, which is insofar as board level governance is concerned. So our suggestion, our argument is that while more research needs to be done, and the reactions that we have seen in the U.S., well, if you're coming from the board level governance, from the corporate governance point of view, are not necessarily empirically or evidence backed. Now that's our conclusion. That's our initial preliminary, if you like, conclusion based upon our research. Thank you for your attention.
Thank you very much for this fascinating talk and the information, but also the ideas that you have presented as to what the way forward is. For the audience, if you have any questions, please again chat them in so that we can present them to Professor Chao. A couple of questions are already in. Let me start with the first question, which relates to the identification, or actually the definition of U.S. listed Chinese firms. You mentioned that there are several, well, the first criteria was that their main operation is in China, but then there were other categories such as board members, such as headquarters, and so on and so on. How exactly did you take these factors into account when identifying those US listed Chinese firms? Are there deal breakers? For example, if the main operation was not in China, whatever main operation in China means, would you keep them out? If, for example, there was one firm that had its main operation in China, but the shareholders were not, the dominating shareholders were not from mainland China, would you kick this firm out? That's the first question. If I may follow up with the second question, would it be more appropriate to focus on the board members rather than on the operation where the company is operating or where the headquarters is? Because we're talking about corporate governance, we're talking about the board's responsibilities here. And the last question, if I may, concerns the length of the appointment of board members. I was recently talking to a practitioner, and he mentioned that the length of the appointment of a board member significantly affects that board member's risk-taking approach, decision-making approach, and so on. Do you have any information about the length of the appointments of board members of those US listed Chinese firms? And does that differ from firms that are not Chinese? Those are the three questions to start with, and we will then get to the questions which we have got. Thank you.
Thank you, Professor Wolf. Now, these are great questions, and these are questions that we ran into during our, well, as part of our research. So I think we have some answers to these questions. Now, the first question, I think, is a definitional question. What is by definition a U.S. listed Chinese firms? Now, I think you mentioned there's a deal breaker question, which is what if the main place venue of operation is not in mainland China? What if the controlling shareholder is not one of one that with an origin in mainland China, for example? Now, these are the questions that we took a lot of care to look into. So the starting point of our research was really the WIND dataset. So the WIND dataset has done their own categorization. So we took that as a starting point, but we didn't really just blindly follow their listing. So we double checked. So for example, something which immediately jump up was a firm which almost by, well, in many different aspects, it just appeared to be a U.S. listed Chinese firm. But then we look at its main shareholder. It turned out its main shareholder is a Hong Kong-based firm, or perhaps a Hong Kong-based investor. So in that case, we took it out from the data set. It's a tricky one. The company I think derived much of its revenue from mainland China, but I think it was really under the control of a Hong Kong-based investor, which is probably quite common as a matter of open door policy, which is Hong Kong-based capital, but with a very strong solid mainland operation. So to answer your question, the quick one is that we do look into different all these criteria. We double checked to make sure as much as we could that all the firms that go into our data set would not escape a scrutiny, our own scrutiny, put it that way. that is to the first question. Now, the other two questions are great questions. So essentially, I guess the suggestion is that while the empirical investigation should perhaps go beyond the board and the board committee, and then go further into individuals, because at the end of the day, which I agree, at the end of the day, it is board members, those individuals, which really have the say. It's not really just the institution. Even decisions are taken at institutional level. Now, I think we would agree, but there are some difficulties that we ran into, which has a lot to do with the observation that we had earlier, which is maturity. Now, it appeared that more matured, which is well, U.S. listed Chinese firms, which went public in NASDAQ or NYSE in early years, in early decade, if you like, they tend to have board members who were non-Chinese. So I think some would there could be different interpretations, but one way of interpreting that is that our firms which are more mature, they are gaining greater confidence to afford to be more international and having a less well, interpersonal relationship with the controlling shareholder. So we looked into that. We thought it could be just by comparing the nationality, for example, and even maybe the tenure, which is also a very important point. Tenure appointment could send in a lot of noise, which we were still not able to back then, able to process, you know, given the short frame of our research, because we wanted to engage the debate. We wanted to rule it out as soon as possible. So we had a time window of 3-4 months to do the data collection, to write the paper, and send it out for public, well, for basically for journals. But if we had a greater time window, I think now we will probably, if we were to do it again, you know, given a bit more time, I think we'll do it that way, which is to look into individual level, to evaluate how independent they are. You know, that sort of research, which will add a lot of value to our research, which I agree.
Thank you. We have more questions coming in. Let me go to the first one from Professor Watanabe from Waseda University in Japan. Thank you so much for a very excellent presentation, Professor Xi. Now in Japan, the Toshiba incident is a very big problem, although it has been said that Toshiba, which is one of the leading companies in Japan, had the most independent government structure. It has caused a big problem repeatedly and lost trust from its shareholders, at last. What do you think about this issue?
Professor Watanabe, thank you for being with us, with me today. It's a great honor. I think you're absolutely right, and this is one of the most heatedly debated question, which I only mentioned in passing just now, as to what exactly independence actually means. In practice, I mean, you're absolutely right. Toshiba is a perfect example. Some would even say even an Enron board was another example, which is, well, if you look at a board, well, in some cases, the only one who is not independent on the whole board was the CEO. But some would, if you take well, I think investigative journalism has shown that, well, that doesn't actually mean much. Some would, if you were to be cynical, because at the end of the day, the appointment decision would, some would argue, come under the influence of the senior management and the CEO. So it could be someone who comes from the social circle, who has no monetary relationship whatsoever with the listed company, which is the focus of the listing rules. The listing rules typically will say, well, the independent board member is not supposed to be a former employee, is not supposed to be somebody who is monetarily related to the company, but somebody who is socially in a close-knit relationship with the CEO. So that's I agree. I mean, independence just on appearance does not necessarily secure independence well in reality. So that's one very important line of literature. Especially, well, you have academics who suggested, independence just doesn't mean much. But there's a big but here, which is, on the other hand, independence. I think, we have shown in one of the slides. Well, even just take independence on its face value. Now, even just to say, well, you have board members who are established figures, who are senior professionals, former government officials, who are socially closely connected to the CEO or the management, who in one way or another, the judgment may be affected by that relationship, even with all these considerations. Empirically, independence still matters. So I've shown all these journal articles, the full, but there's a large body of literature, empirical literature, which shows statistically, I think I should emphasize that. So Toshiba, Enron, individual cases, they show independence may not be necessarily be sufficient to prevent a corporate scandal from happening. But statistically, from a systematic point of view, if you look at all these listed companies as a whole, systematically, I think empirical research has shown now independence still matters because greater independence is statistically correlated and causes this causality relationship between greater independence and a lesser financial fraud and greater shareholder value. So I think from that point of view, from an empirical point of view, from a systematic point of view, from the statistical point of view, independence still matters. So I think really, Professor Watanabe, your question boils down to the question of exactly how. I mean, why should socially connected, you may say, well, these are just all social elites. These are just social friends. Why should they care? Why should they bother to act in the interest of the public investors? So I think empirical research is really in the last 5 years. There have been some very recent empirical research to suggest that independent directors, they're not just puppets. Because reputation has played, for example, play a large part in moving independence to do things, independent directors to do things that their CEO friends, social friends may not like. For example, they will resign from time to time. They will say, well, I have no disagreement with the incumbent management, but the market pick up the message. So reputation-wise, market employability wise, these independent directors, they typically act as independent directors in more than one firm. There's a market for independent directors. They don't want to ruin their reputation. They don't want to lose their marketability, put it that way. So they will jump the ship. That's the message. They'll jump the ship at the first sign of a risk of the ship sinking. They will jump the ship. They will send a message to the market, and that's probably what it is. But Professor Watanabe, I agree. We cannot explain really individual cases. Toshiba is one prominent example, counterexample. I absolutely agree.
Thank you very much. We are running out of time, but we have a couple of more questions. So, Professor Chao, if you could.
I'll be brief.
Next
right.
question from Mr. or Mrs. Thank you, Professor Chao, for an illuminating talk. The very attractive title is Analyzed Based on Independence of the Board by the Regulation of Governance in the U.S. Listed Firm. I understand. Quite different from, and this is quite different from the UK based, namely Hong Kong governance structure. Are there any other suggested dimensions that we could measure in order to come to understand this whole phenomenon?
Right. Well, thank you, Mr. for this excellent question. It points to a broader issue, which is the market structure, the share ownership structure. I guess the thrust of the conventional wisdom, I won't go into the most recent literature, but the conventional wisdom is that the U.S. market is known to be dispersed in ownership. So you don't really have, typically, you don't really have a one single controlling shareholder or family or or other founder family typically, which holds a large percentage of the shares. Now, obviously, you might say, what about a Facebook? What about Alpha? Well, other, these are more recent new economy firms. But leaving those firms aside, it generally is dispersed ownership. So in that market, independent directors, presumably, at least a theory suggests, would play a larger part than the market where concentrated ownership is the norm. Now, I suppose you know what market I'm looking at. For example, Hong Kong. Now, so if you look at a Hong Kong market, you're looking at a very different market structure. So here, family-controlled firms, or otherwise firms which are controlled by one single controlling shareholder and its close-knit associates appears to be the norm. Now, the value of independent director in this kind of market structure could be very different. So I think if anything, if you're looking at Hong Kong, I suppose, the ownership structure is something that you might take some interest.
Thank you very much. A question from Mr. Todd Zhang. In your opinion, would the Holding Foreign Companies Accountable Act be stringent and capable enough to weed out all unstable firms, in quotation marks, like Luckin Coffee in the future?
Mr. Zhang, a great question. Okay, I will be honest. The quick answer is that we don't know yet. We don't know the full effect, the full force of the Holding Foreign Company Accountable Act might really be. Now, going to the legislative intent of that act, the intent clearly was to increase the so-called transparency of the audit paper, to hold companies, basically Chinese companies. Well, there are a couple of other jurisdictions, France. I think there's very small number of jurisdictions which wouldn't allow U.S. regulators to have access to the audit paper. But those jurisdictions, most of the jurisdictions have surrendered to the pressure. China still stand out as exception. So in that sense, the legislative intent is basically comply or go up. To what extent that will be able to achieve its legislative intent will have to be answered in the broader, the ongoing Sino-US political trade, geopolitical trade, economic tension, how that plays out. And I think we're still very early in the Biden administration. I think still things are still playing out, so we don't know yet. To be very honest, so we'll see. We'll see what happens. But just as a joke, I would say the worst. You can't call it a best case scenario or worst case scenario, depending on where you come from. But one scenario will be a large percentage of the firms. The 224 firms, will get delisted in 3 years' time, and a good number of them will come to Hong Kong. And then we were looking at a very different scenario. So in a way, I feel sorry, Mr. Zhang. I don't really have an answer because it's a moving target. No one perhaps knows exactly, but this is something which I think we'll keep an eye on.
Thank you very much. My next question would have been, but you've almost given the answer, is whether nationality of companies, listed companies, still matters in a globalized world. But you've just explained that probably it does because of the political environment.
That's right.
Thank you very, very much again for a very enlightening talk and also the great Q&A session. Many thanks to all the participants, to those who have chatted in questions and those who have just participated.